Now I would like to discuss a case note on the Pegasus ARC versus Haryana CONCAST Limited. This is a recent Supreme Court judgment of 2016. Overview of facts. The matter in the landmark case of Pegasus Assets Reconstruction Private Limited versus the Haryana CONCAST Limited arose out of the Companies Act 1956, the SARFAESI Act 2002, and the apparent conflict between them, specifically Section 529A and Section 529 of the Companies Act and Section 13 of the SARFAESI Act. The judgment dealt with 4 cases that were clubbed together after conflicting judgments were passed on the matter by the Punjab and Haryana High Court and the Delhi High Court. Section 529A of the Companies Act of 1956. Section 529 of the Companies Act provides that the dues owed to the workmen shall be deemed to be pari passu with the charge imposed by secured creditors on the company in case the creditors choose to enforce the security through insolvency laws. Additionally, this parity between the claims of workmen and creditors must be effected by the official liquidator appointed for the winding up of the company, who shall represent the workmen in winding up proceedings and thereby enforce their charge. Section 529A then provides that in a scenario that the secured creditors attempt to realize their charge during winding up, that is, through sale by the official liquidator, then the dues owed to the workmen shall be paid first and foremost, and therefore after the secured creditor can claim their dues. On the other hand, Section 13 of the SARFAESI Act provides the secured creditor with an alibi, with an ability to enforce his or her charge or security interest without the intervention of courts or tribunals by taking possession of the secured property or taking control of the management of the defaulting business. What were the issues pleaded in this case? As a consequence of the provisions of the Companies Act, the company judge imposed certain restrictions on the enforcement of security interest by a secured creditor under the SARFAESI Act so as to ensure compliance under Section 529 and Section 529A of the Companies Act. The Delhi High Court found these restrictions to be in conflict with the SARFAESI Act, while the Punjab and Haryana High Court had held that the company judge could in fact place such restrictions. Now, what were the 2 pertinent issues that were raised in the case? First, whether any power can be exercised by the company court directly or through an official liquidator in relation to the sale of a secured asset by a secured creditor in accordance with the provisions and rights stipulated to the creditor under the SARFAESI Act. Second, whether a later offer bettering the previous sale price in an auction is valid. The reasoning of the high courts. The 2 high courts chose very different lines of reasoning and argumentation in coming to diametrically opposite conclusion with regards to the relationship between Companies Act and SARFAESI Act and the priority to be afforded to secured creditors vis-a-vis the workmen. First, the Delhi High Court. The arguments advanced by Pegasus. First, Pegasus argued that SARFAESI Act was a complete act in itself and had to be interpreted as a standalone code without any reliance taken from the Companies Act. Non-intervention by the courts and tribunals formed an essential part of the Act, which was clear from the non-obstante clause present before most section of the Act. Third, the framework provided for the enforcement of secured assets and the non-obstante clause provided for in the SARFAESI Act not only reflect the fact that the Act is a complete code in by itself, but also that in situation of conflict with other law, the Act being the specialized legislation in the field would then have an overriding effect over the other laws. Fourth, other statutes as provided for in Section 37 of the Act, such as the Companies Act, only complement and supplement the provisions of the SARFAESI Act. As these acts are only subsidiary to the SARFAESI Act, they may be relied upon only insofar as they are consistent and not contradictory to the provisions of the SARFAESI Act. Now, what was the judgment of the Delhi High Court? The judgment of the Delhi High Court gave great weight to the aforesaid arguments presented by Pegasus and made 2 main conclusions as to its judgment. First, the court first held that the association of an official liquidator with the sale of secured assets of a winding up business would result in defeating the purpose of the SARFAESI Act, which envisaged minimal judicial intervention and sought to provide secured creditors with an efficacious remedy. Secondly, additionally and quite conclusively, the court held that the SARFAESI Act is a complete code in itself. This means that the rules and provisions given under the Act would prevail over any other legislation, in this case the Companies Act, in the case of conflict. Now, what was the decision by the Punjab and Haryana High Court? The Punjab and Haryana High Court, on the other hand, took a different approach and allowed for fetters to be put in by the company judge on the sale of secured assets by secured creditors so as to ensure pari passu treatment of workmen. The court relied upon the case of Rajasthan State Financial Corporation, wherein it was held that a financial corporation had the right to proceed against the debtor in accordance with the provisions of Section 29 of the SFC Act, only if so long as there was no order of finding up passed against the debtor company. In situations wherein such a winding up order was passed, the provisions of Section 529 and 529A of the Companies Act would have to be respected, and a pari passu charge in favor of the workmen would have to be effected. Such charge would then be effected through the representation of the workmen by the official liquidator. The court relied upon the Bank of Maharashtra versus Pandurang Keshav case, wherein in the act in question was the RDDFI. The case held that the DRT cannot adjudicate upon the dues owed to the workmen by the debtor company, and the same could only be decided by the official liquidator under the Companies Act. Finally, the Punjab and Haryana High Court referred to the Employees Provident Fund Commissioner versus the OL case. This case dealt with the dues payable by an employer under Section 11 of the EPF Act 1952 and the conflict with Section 529A of the Companies Act. It was held that Section 529A has a priority over in case of the Companies Act. The SARFAESI Act took care of the interest of the workmen through its own provisions by means of association of official liquidator with the proceedings before the DRT under the RDB Act. Similar interpretation must be taken in contention with the SARFAESI Act, as well as other reason being so that Section 13 requires notice to the borrower at various stages. So the Punjab and Haryana High Court, thus going by the past direction taken by a few high courts and perhaps a welfare intent cited in favor of workmen, held that in situations of conflict, the workmen will be held pari passu with the Companies Act. Now, what was the decision of the Supreme Court analysis? The apex court sided with the opinion of the Delhi High Court and granted priority to the SARFAESI Act. In coming to this decision, the court relied on several factors and thereby gave the following issues. The reasons provided by the Supreme Court were, firstly, that there existed no inconsistency between the Companies Act and the SARFAESI Act, as Section 529A of the Companies Act was specifically mentioned in Section 13 subsection 9 of the SARFAESI Act. Secondly, the intent behind the passing of the SARFAESI Act was minimal judicial intervention in ensuring that the secured creditor could enforce its security interest as provided for in Section 13. The Act also ensures that in case of any grievance, the liquidator will have the right of seeking redressal under Section 17 and 18 of the SARFAESI Act. The respondents had failed to show that there existed ambiguity in the SARFAESI Act which required reliance upon the provisions of the Companies Act. The court then went on to compare the three legislations taken into consideration by the Punjab and Haryana High Court, that is the SFC Act, the RDDBFI Act and the SARFAESI Act. Upon a comparison, the court found that while the first two acts could be surpassed by the Companies Act, the SARFAESI Act is a complete code in itself. And the reasons provided were, Sections 9 and 13 of the SARFAESI Act strongly indicate that for the enforcement of the security interest of the secured creditor was provided for exhaustively and with a detailed procedure within Section 9 and 13 of the SARFAESI Act, and the same was to be effected with minimum intervention of the court or tribunal. Moreover, the proviso to subsection 9 of Section 13 provided for detailed instructions, being mindful of the provisions of Section 529 and 529A of the Companies Act of 1956. The proceedings under the RDDFI Act have been previously upheld by the judiciary to prevail over the other laws, as it was a law enacted later in time. While Section 529 was amended by the insertion of Section 529A in 1985 and workmen's dues preference over other dues, however, the RDDFI Act was passed in 1993 and therefore acted as a priority legislation over Companies Act. The SARFAESI Act rules framed under SARFAESI Act also require that notice be given to the borrower or his agent at different stages. Thus, the rules ensure that the OL has the knowledge of the proceedings under the SARFAESI Act in case the borrower happens to be a company under winding up. Now, reconciling the SARFAESI and the Companies Acts. Several provisions within the SARFAESI Act itself ensure protection of the interest of workmen and enable them to realize their dues without any association of the official liquidator. The Act provides the liquidator to raise an appeal to the DRT in situation where the liquidator is not satisfied with the remedies provided to the workmen. Additionally, a further appeal under Section 18 is also envisaged as a further safeguard. Several protections are already present in the legislative scheme to ensure adequate safeguards to workmen, and the same can be achieved without providing further powers to company court or the official liquidator to interfere in the sale of secured assets. There is thus no need to borrow anything from the Companies Act till the stage the secured assets are sold by the secured creditors in accordance with the provisions in the SARFAESI Act and the rules. Furthermore, even in accordance with the provisions, the rights of the workmen are protected by subsection 9 of section 13 and its 5 provisions. Thus, the necessary provisions of the Companies Act have been incorporated in the SARFAESI Act to protect the interest of workmen and also achieve harmony between the two acts. Therefore, the company judge cannot interfere in proceeding by a secured creditor to realize its secured interest as per provisions of the SARFAESI Act.